LLC and Vneshprombank others.
Now, just give me a second, Mr. Bennett.
Right, he's here. Oh yeah, would you like to say if you like to?
That screen.
I think we just need to back where it is.
I just tried.
It was working there.
It was working a few minutes ago.
Let me just get that.
Click that button.
Let's do it.
It's not gone blue.
Perfect. What was wrong with it?
I think it just
It's gone to sleep, Mr. Bennett.
Is that there?
must be the only thing in this courtroom which has,
Right.
my lord, my lady, in this matter, I appear together with my then friend Mr. Cullen for the appellant, Mr. Bedzhamov. Then from Mr. Georgy appears for the respondent. There are three elements to the hearing before you, which I just summarised. Firstly, of course, my appeal. Secondly, my application to produce fresh evidence, where the court will see that since that application, the respondents filed a number of witness statements and we have responded. Third, the remittal application. I can tell the court...
The what application?
It's described as remittal.
Remittal.
And if I can just help the court, that is no longer live. It is now been agreed last night that in the event that the court were to dismiss my appeal, there would be an order that the funds should remain in court until the application which we have made on the hypothesis we failed to Mrs. Justice Falk for a variation to the consent order arising out of the Ukrainian sanctions until that is heard. So the court doesn't need to be concerned with that aspect. Both parties have agreed that in the event that it becomes live because my appeal has failed, then both parties will cooperate to bring the matter before Mrs. Justice Falk.
So why does all the stuff about sanctions matter, the additional evidence? How does that add to the debate that we have to decide, which is the question of whether or not Mrs. Justice Falk was correct to say that the order had been complied with?
Lord, its relevance is, of course, less given last night's agreement.
Well, it's not. It's nothing, isn't it? It's no relevance now.
Lord, I'm not sure that's quite right, because as I will develop when the court looks at all the circumstances of the case, where we have a position where person providing the guarantee, A1 LLC, has been, at least until recently, and may still be, under the ownership or control of three sanctioned individuals, then that is relevant to the question of whether the effect of the advisory note is such that the court may anticipate that there will be, or may be, attempts to avoid payment under the guarantee. All I'm concerned.
There'll only be sanctions at all if the order is not complied with. You're not relying on the timing default. You rely on the Credit Suisse default, Credit Suisse wording, and the default in the sense of the advisory note. And if you're wrong about that, then there's nothing to relieve. So there's no all the circumstances of the case. If you're right about it, then we know anyway that things have changed dramatically. I mean, we don't live in a bubble here. We know about the war in Ukraine and about the sanctions against Russian entities, including some of the people involved in this case. So, what more do we need to know?
Well, probably very little when we come to it.
Okay, well, let's see where it goes when you come to it.
Well, before I begin, I want to make just a few preliminary points, which are relevant to considering the position. Firstly, the application which led to the consent order did not concern what form of security should be ordered, as is normally the case, but whether when security had been ordered in the form of a payment into court, that order should be varied so as to prevent money currently in court, some £4 million, to be removed from court and replaced by a guarantee. And that brings into sharp focus the question of whether the guarantee as provided is effectively as good as money in court.
Well, why does it bring that into focus? All it brings into focus is whether the agreement that is reflected in the consent order was performed or not. Surely.
Well,
you say that at paragraph 58 of your skeleton argument.
Yes, Lord. The fact that the money is in court is, if one is simply construing the consent order, that might be the case, but we're going more than that. If I just continue for a moment, it will become, I hope, clearer. The application and the order was sought not for the benefit of the claimant itself, but for its funder. And the reason for that was allegedly so that they could use cash for investment to gain a higher rate than they would get through court funds. But in circumstances, of course, where this funder, as with any other funder, will, on the terms of its funding agreement, which we don't know about, the court doesn't know about, have already made provision for what return it gets for the use of its funds by way of costs and security.
So who's the funder? I mean, what do we know about this? Is there evidence about the funding?
We know it is accepted that all the funding for the action brought by the DIA as liquidator of Vneshprombank has been provided by A1 LLC throughout. For
A1 LLC, which is what, a Russian corporation or
it's a Russian
partnership, or what is it?
It's a Russian corporation. And as I say, they wanted to have the money out, they say, for that purpose. But of course, the effect of the consent order is that the money will no longer be there. And
Well, you agreed to it. I mean, you can't come here and say it's terrible that the money is being replaced by a guarantee. You agreed to the money being replaced by a guarantee. Nobody asked you to.
Yes, I did, and I'll come to that immediately. We agreed because the guidance is usually that if security can be provided in the form of a guarantee, which is likely to be paid on demand, without query, from a reputable institution, then the court will normally accept that as adequate security. We made clear from the outset that provided that we had a straightforward guarantee, unconditional on-demand guarantee from a UK-based bank, that would be sufficient security, seeking to avoid an unnecessary battle. And what I will be saying throughout is that that is not what we have got. And of course, that is the rub of it. The last point I want to make, which goes to the question which my Lord the Master of the Rolls asked about whether all the circumstances of the case come into it at all, is this is, as Mrs. Justice Falk correctly recognised, not strictly a relief from sanctions application, but an application to vary. The effect of the consent order was that if the guarantee was not provided in the agreed form by the specified date, the permission to remove the money from court fell away, and the order for security would remain as it had been made by the learned master at various occasions during the course of the proceedings. And what this claimant was seeking to do was to vary that consent order. Firstly, so that it continued to exist, although it had in fact expired. And secondly, so that it was held valid despite the differences in the wording of the guarantee and irrespective of the advisory note. In the circumstances where, as the court well knows, authorities in the bundle.
You're going to have to speak up, Mr. Fenwick. You've got traffic over there, and you're dropping your voice at the end of every sentence, and I, for one, can't hear the whole thing, and I need to.
I appreciate that, my Lord. I fear that 2 years of talking to a screen may have led to habits which didn't previously exist, and I apologise.
Please use your loudest tones.
So the position is that, strictly speaking, they need the court to agree a variation of the consent order in their favour, both as to timing and as to wording. And that is something which the court will occasionally order, but in doing so will have regard to all circumstances of the case to see whether it is fair to do so. And it's not simply a matter of looking as Mr. Georgy sought to persuade the learned judge at, does it look more or less the same? Is it the same? Therefore, is there anything that I need relief from sanctions for? It's much more nuanced than that. I've already indicated that Mr. Bedzhamov's approach, when asked to agree to a guarantee in substitute for money in court, agreed provided that it was an English or UK bank guarantee. Initial attempts to provide something back to back in a complicated fashion were rejected. There was then an agreement to provide a guarantee in which Standard Chartered would confirm that they knew of no reason why they shouldn't be able to pay. They then decided that they wouldn't do so, but did agree that they would pay the money into court if ordered. That was an important element at that stage, because the expectation or risk was that the Russian authorities, who, as the court has seen, do not look favourably on Mr. Bedzhamov, would, if necessary, and if it came to an order against the DIA, which is an emanation of the Central Bank of Russia, the official, effectively, liquidator of banks, were to be ordered to pay money. And if Mr. Bedzhamov was sanctioned, there might be an argument that money couldn't be paid out of Russia or through Switzerland. And if the money was in court, then it was anticipated that the court at least could make the decision. Now, the first issue and the starting point is whether the security provided overall is substantially the same as that agreed. But that is not, in my submission, the end point, because if what was provided was not effectively as good as money on demand or as good as money in court, then the security which had been stipulated for and agreed has not been provided, and the court should not, in its discretion, permit Vneshprombank to remove the money from court. Now, it's probably sensible, if we may, to go directly to the documentation as being at the centre of the construction argument. And I've been looking at it for convenience in core bundle 2, and we can see the terms of the last order at page 137 in tab 15. And that varied the order and said that the consent order should be varied so the form of bank guarantee shall be in the terms set out in Schedule 1 to this order, not in the terms set out in Schedule 8 of the consent order. And then the provision, if it hasn't been provided by 12 p.m. on the 19th of February, the permissions shall cease to have effect. The form of security for costs in these proceedings shall remain as previously ordered. And in my submission, that means exactly what it says. The guarantee not having been provided in the correct form nor on time, the permission ceased to have effect, and therefore a variation was needed.
Well, the question is whether such guarantee and copy of the register of authorised signatory had been or was provided. Timing no longer matters, because you've not appealed that point.
Timing no longer matters, except the fact that it was accepted that the court should have regard to all the circumstances of the case.
I don't understand. My point is, the question is whether or not, under this agreed paragraph of the order, the guarantee, such guarantee, and copy of the register of authorised signatory was provided when they sent it over in the way they did with the covering note. That's the question. That's the first question.
That is the first question.
If yes, then that's the end of your appeal.
No, with respect, it's not the end of my appeal, because it's common ground that what is required is a variation. And variation requires consideration of all the circumstances of the case.
Well, I mean, forgive me, if the guarantee and the copy of the register was provided, then no variation is required.
I understand your Lordship's point.
Yes.
If we go to page 139, which is the what was ordered, agreed, we see reference to dispute. We understand, according to condition of claim, VPV is required to make a payment by way of security costs. Limited Liability Company A1, that's the funder, is the applicant of this guarantee.
I'm very sorry, I'm not on the right page.
139, my
Thank you very much, I am.
We, Standard Chartered Bank, irrevocably undertake to pay the beneficiary amounts on first demand. In the next paragraph, in the event the order shall require payment into court rather than to the beneficiary, the said sum shall be paid to the court office. Now, what in fact arrived, a little late, starts, well, what's on page 140 is not what reached my then solicitors, but what was apparently sent to Credit Suisse on the same day, as we subsequently discovered. That refers to the instructions confirming having issued the guarantee, dispatched Mishcon de Rea. Please review the enclosed copy to ensure it's been issued according to the instructions. Then about repeat guarantees. Then the two parts of the wording which we complain of. Firstly, all parties to this transaction are advised that banks may be unable to process a transaction that involves countries, regions, entities, vessels, or individuals sanctioned by the United Nations, etc., and or regulatory authority.
Sorry, I haven't got the page now.
No.
140, my lord.
No.
Well, it doesn't.
This is a letter addressed to Credit Suisse.
Right.
And it's background because it's there showing that Credit Suisse is being told the same thing.
Oh, right. All parties to this transaction. Got it.
Yes, but this goes to Credit Suisse. And then the next paragraph, SCV is not liable if it or any other person fails or delays to perform the transaction or discloses information as a result of actual or potential breach of such sanctions. Now, I'm just showing you that before I show the same thing at page 142. And this is the advisory, and of course the URDG provides for an advisory of somebody actually providing the guarantee to the beneficiary. As requested by our customer Credit Suisse, please find enclosed the original above guarantee for onward transmission to Michigan and Berea.
So do you say that is a part of the performance bond provided by the bank?
It is part of the documentation provided by the bank. And I'll develop that if I
Is
may.
it part of the guarantee?
It qualifies the guarantee in terms. Because it says, in terms, SCB is not liable if it or any other person fails or delays to perform the transaction or actual potential breach. So it is setting up an assertion that it will not be liable in certain specified circumstances, which I'll develop.
And on what basis is it incorporated as part of the guarantee? I mean, it's pretty well established, isn't it, that commercial documentation of this kind is to be construed strictly, right? And it's to be construed strictly, and it's not normal to take into account. I mean, if, for example, they'd written a letter saying, "Dear Credit Suisse, here's our guarantee," or whoever, "here's our guarantee. Of course, we're never going to pay. Ho, ho, ho." Right? Is that part of the guarantee? Is that document part of the guarantee, or is the guarantee to be construed on its terms?
Oh, my lord, that is an example of interaction between the guarantor and the applicant or provider of the counter guarantee, and it doesn't affect the rights as between the guarantor
No,
and
if
the
you wrote
beneficiary.
that to everybody. If they wrote exactly equivalent to this. They wrote to everybody, "Dear everybody, here's our guarantee in accordance with the order," or "here's our guarantee. Of course, we're never going to pay. Ho, ho, ho." Is that incorporated into the guarantee? Is it a term of the guarantee? How does it affect the guarantee?
I would not expect any court to regard that as qualifying the guarantee.
Well,
That is
then
an
that's my
extreme-
point.
That is an extreme example, my lord. If, on the other hand, you have a document which says, I'm attaching my guarantee, this will only come into effect and force if X, Y, Z. And what you do is you do what you do here, which is you send it as part of the same package to the same person, you date it on the same day, you give it the same reference, and you make it part of the notification of the guarantee to the beneficiary. All of those characteristics are intended clearly, and I'll explain more reasons why in a moment, to tell the recipient that they should have regard both to the attached document, like the guarantee as such, and to this document, which purports to qualify the obligations of Standard Chartered Bank, not simply if it is prohibited by sanctions from doing something, which doesn't need to be said, because of course they're bound by it as a matter of law, but if it or any other person fails or delays to perform the transaction as a result of actual or potential breaches. So a lot of uncertain wording being introduced. And that is telling.
But don't you, Mr. Fenwick, have to get to first base? Do you not need to explain why this clause is to be construed as being part of the guarantee? I mean, if it's not, and you quite fairly accepted that if you'd said simply, I'm not going to pay, that would not be part of it. So the next question is, why is this part of it? When it is simply, in another way, saying we won't pay if we're prevented from doing so by sanctions, and some uncertain language to that effect.
I have to satisfy the court that this forms part of documentation and qualifies or purports to qualify the protection which is given on the face of the guarantee. That, in my submission, is sufficient for my purposes.
Sorry, can I just get that down precisely? I have to satisfy the court that this forms part of the documentation sent by the bank, yeah, and
it was purported to and appeared to qualify the obligation of the bank beyond strict compliance with the law.
sorry, I need to get that wording. And it purported to, or actually did,
Or appeared
to
qualify
qualify
the obligations of the guarantor beyond that which was required by law.
Beyond that which was required by law, you mean beyond what in any event would be the effect of the sanction legislation?
Yep, exactly. And I'll show the court in a moment what I mean by that. Now, we know, and it's in the documentation, we go there if we need to, that Standard Chartered Bank say they include this with all their guarantees. We know that they declined to withdraw it. We know that they declined to provide any comfort as to what they would do, and specifically as to whether they would actually pay the money into court if required to do so. Now, if we go to the guarantee itself, starting page 143,
this is in core 2.
yes, my lord.
Yeah.
There we have added wording at the request of our client Credit Suisse and under a current counter guarantee issued in our favour from Credit Suisse, we Standard Chartered Bank, we offer to pay. It also includes, so that's a reference to Credit Suisse and a reference to a counter guarantee, which does not in itself, I accept, affect the enforceability of the guarantee as such. And it refers to Limited Liability Company, A1. A1 and Credit Suisse are, of course, any other person who might perform the transaction. Because if, going back to the advisory, performing the transaction was a matter only for Standard Chartered, then it would be Standard Chartered not liable if it fails or delays to perform the transaction. It expressly expands the exclusion of liability to situations where any other person, which must be construed sensibly, fails or performs. And both the counter-guarantor and A1 as the applicant must be intended to be included in that definition, if it means anything. And I understand Master Kaye's point about that, and we'll come to that. If we go to the next page, page 144, we see the reference to the guarantees subject to the URBG to the extent not inconsistent with the express terms of this guarantee, and then English law, English jurisdiction clause. So that brings about reference to inconsistency and to the rules. And I'm going to go directly, because it's, I think, helpful to do so at this stage, to what there is in our supplemental bundle at tab 6, page 117. And this is a guidance paper from the ICC. We just go back a couple of pages. 115 is guidance paper on the use of sanction clauses in trade finance related instruments. If we go to 116, it's use of sanctions clauses in trade finance related instruments subject to ICC rules, including demand guarantees. So it's directly on point. And then introduction on 117. The use of clauses in relation to trade, economic or financial sanctions or embargoes in trade finance related instruments that are subject to the rules drafted by the ICC Banking Commission. Takes us back to IDRG. Stating banks' intention to comply with sanctions regulation has become a problematic issue for banks involved in trade finance transactions, including demand guarantees and counter guarantees. And then it has some general wording about the effect of sanctions restricting a bank's ability to perform the role under ICC rules. And then at the bottom of the page, the purpose of the guidance paper is to highlight certain issues arising from the use of such clauses and recommended best practice in that respect. Over the page, 118. Concerned about the implication of sanctions for their own obligations under trade-related transactions, seeking to notify their counterparties, whether correspondent banks or beneficiaries, banks sometimes include so-called sanctions clauses in transaction documents. There is no standard for these clauses. They vary considerably in their scope. Where they simply state the bank is under a statutory duty to comply with sanction laws and regulation mandatorily applicable to it, they're merely informational and do not extend beyond applicable laws and regulations. And then there's a boycott clause, which we don't need to look at. 2.4. If the sanctions clauses in trade finance related instruments, including letters of credit or demand guarantee, allow the issuer a level of discretion as to whether or not to honour beyond the statutory or regulatory requirements applicable to that issuer, they bring into question the irrevocable and documentary nature of the letter of credit or guarantee. The implementation by a bank of an internal sanctions-related policy that goes beyond what is required under the laws and regulations applicable to that bank is an illustration of that discretion. It may cause a serious problem when considering the role of a confirming bank, nominally transferring bank, a guarantor or a beneficiary. If the reference to an internal sanctions-related policy were to allow the bank discretion to honour or refuse payment, one could even question if the bank has in fact assumed a legally binding obligation, a question that of course has to be determined under the applicable law. Particular concern, the clause that purport to alter the reimbursement provisions, and then further down, the end of the paragraph, the same concern arises for guarantors that have acted pursuant to the instructions the counter guarantees received from counter guarantors. Where sanctions clauses refer to banks' internal requirements, appear in the letter of credit or counter guarantee, the nominated bank is in a difficult position as it is not aware of the internal sanctions policy the issuing bank might elect to apply. Such a policy reports have a broader scope than that of sanctions laws and regulations applicable. As a matter of mandatory law, the issuing bank, the nominated bank would face uncertainty as to whether it will be reimbursed and should it pay a complying presentation. As a result, the nominated bank's risk assessment is likely not only to include issuing bank and country risk, but also the likelihood of a prohibited reimbursement due to sanctions regulations or internal sanctions related policy. This may result in increased costs, delay, and potential disputes. Then goes on to give some examples. First one, 119.
I mean, why are we looking at this?
Because, well, this is the ICC responsible for the IDRG identifying the fact that the inclusion of sanctions language which purports to qualify the liability of the bank by giving it a discretion. So it's not if prohibited by law, or if the court tells us not, is precisely that which this advisory note actually constitutes. And it is an example of a sanctions clause which does go beyond simply stating what the law is. It does purport to say there will be no liability to pay if any party delays or fails to perform because of actual or suspected sanctions.
Did the judge accept that it was part of the contractual obligation?
The learned master concluded that they were.
Now, I know the learned master did, but did the judge accept that this was part of the that the advisory note was part of the contractual obligations in the performance bond?
No, she held that it was purely advisory and didn't qualify it.
Right. So she held it was purely advisory. And where is your ground of appeal that attacks that finding? I'm just looking at the core volume part 1.
Yes.
You say, had the effect of creating uncertainty and scope for dispute.
And then we say at grounds, it is wrong to find provided with a guarantee in the form contemplated, because the provision of the bank guarantee, together with the note, which referred to appear to seek to qualify the obligation, was a substantial departure from the parties' agreement as to the form of security.
Right, but now you're arguing something different, which is that it was a part of the contractual obligations, and the judge had been wrong to find that it was not.
It was put forward, it has been put forward by Standard Chartered with the intention, clearly, if Standard Chartered adds this to all its guarantees, it does not do so because it likes writing things on bits of paper. It does so because it intends to say something about qualifications to its obligations under the guarantee.
No, I understand, but I'm just trying to get clear what this appeal's about, Mr. Fennick. The problem I've got is that I read your skeleton as saying your complaint is that she, the judge, failed to realise that she should not have been determining whether the guarantee included this clause without the presence of the other parties, not that she decided that question wrongly.
No, but Lord, the argument I'm putting forward is illustrating what it is that we can assume, first of all, that Standard Chartered was advised not to do by the ICC, secondly, which they had determined that they would do, and thirdly, which they put forward in terms which appeared to be intended to qualify the guarantee. Now, whether they succeed in it or not is a matter which can only be determined substantively if they have the opportunity to put forward their arguments, if they don't want to pay.
Is that right?
Yes, yes, because it may well be that when the court has a hearing, say, I'm sorry, Standard Chartered, you may have put this in your guarantees, you may have wanted.
No, I understand it would be determined substantively as between all the parties at that stage.
Yeah.
But if the judge formed the view at this stage that the advisory was not part of the guarantee, then that is a very material question to the question of whether the order was complied with, is it not?
Of course it is a material consideration. It's very material, but it's not the end of the story. Because where we are looking at, one can't look at these things as little black letter law. This is intended to provide security, which is as good as reasonably can be provided as a substitute to money in court. That's what the consent order was provided for. That's what the wording of the consent order said. We're going to get this guarantee plain vanilla, no qualifications. We're going to have a UK bank saying, on first demand, we will pay. And that's not what we got. We got a UK bank putting forward a document which on its face said we will pay, and then accompanied it in a way which was clearly intended to be taken into account by the recipient as saying, well, we won't in these circumstances, and it's discretionary and not pure law. So what Mr. Bedzhamov has got from this is something which means that if there was no advisory note, guarantee was called upon, and Mr. Bedzhamov asked for it, Standard Chartered would either pay, or if not paid, one goes trotting down to court and gets an immediate order, to which there could be no possible argument. In this case, we have a very reputable bank with no doubt a horde of legal advisors who take account of the fact that the ICC guidance says they shouldn't do it, and says that
It didn't say that. I didn't read it saying that at all. It said it causes confusion and can cause litigation.
Causes litigation and may cast doubt on the...
It doesn't say whether they should do it or not.
Well, I think it's... it doesn't say it shouldn't do it, but it's clearly... well, it actually does, if I might say so. Page 120.
Right.
It's recommended banks should refrain from issuing instruments that include sanctions clauses purport to impose restrictions.
So you hadn't shown us that.
I'm sorry?
You hadn't shown us that.
I'm sorry, I hadn't shown that.
It is recommended that banks should refrain from issuing trade finances related instruments that include sanctions clauses that purport to impose restrictions beyond or conflict with the applicable statutory or regulatory requirements. So it's not.
But all of this is concerned with sanctions clauses, and if you go back, isn't the document, isn't the ICC thinking about sanctions clauses in the sense of something which is within the four corners of the guarantee? Isn't that what they're discussing?
Well...
And our situation is slightly different.
if one goes back to 118, it talks about including documents in transaction documents.
Yes.
The question, therefore, and I'll come to UDR RDG in a moment, but the question is whether this is simply dealing with the guarantee itself or transaction documents, and it answers the question. 2.1 is dealing with transaction documents, and in my submission, it is well within the realms of possibility that Standard Chartered would seek to argue that the mere fact that the advisory note was in a separate document with the same reference did not give it any significantly less impact than if they'd put it within the four corners of the guarantee. And I'll come to the four corners rule in a moment, because in my submission, it doesn't quite mean what Mr. Georgy submits in relation to it in every circumstance. So
Mr. Bennett, your broad submission is the package, being the guarantee plus the advisory note, creates sufficient uncertainty and the possibility that Standard Chartered will seek to exercise a discretion then to say that they're entitled to, because of their advisory note, means that taking that together, the schedule to the consent order has not been complied with. That's it in a nutshell.
it is. Yes. Can we go next to URDG and just have a look at what that says, which is relevant. That's at the back added to the bundle of authorities.
This is expressly incorporated into the guarantee.
I'm sorry?
This is expressly incorporated into the guarantee.
Yes. And if we have it at tab 10, page 396. And as the court, of course, knows, these are the ICC uniform rules, and therefore the ICC guidance, which I've taken you to, is particularly relevant when considering it. I just wanted to pick up a couple of points in the articles. First of all, Article 3, interpretation, page 411. Except where the context otherwise requires, a guarantee includes the guarantee and any amendment to either a guarantor includes a counter guarantee and a beneficiary includes the party in whose favour a counter guarantee is issued. So it's including it within the guarantee, and that's important if one goes back to the wording in the advisory note of fails to, or delays or fails to perform the transaction.
Is that what that clause means? Doesn't Article 3b simply mean that when these articles refer to a guarantee, they also apply to a counter guarantee?
Yes, it does. But
it doesn't mean the counter guarantee and the guarantee is one transaction.
No.
And isn't there an article which says they're independent of each other?
I accept that. Then go to Article 5 on page 412. A guarantee is by its nature independent of the underlying relationship in the application.
Where are you? Article 12?
412.
412. Yeah, thanks.
Article 5.
Yeah.
Article 5. Guarantee is by its nature independent of the underlying relationship in the application. The guarantor is in no way concerned with or bound by such relationship. Reference in the guarantee to the underlying relationship for the purpose of identifying it does not change the independent nature of the guarantee. The undertaking of a guarantor to pay under the guarantee is not subject to claims or defences arising from any relationship other than a relationship between the guarantor and the beneficiary. So that's what Article 5 says. And Article 5 and the guarantee standing on its own without the advisory note would mean that whatever happened under the counter guarantee wouldn't matter. Page 414, Article 10. A guarantee may be advised to a beneficiary through an advising party. By advising a guarantee, whether directly or indirectly, the advising party signifies to the beneficiary, and if applicable to the second advising party, that it satisfied itself as to the apparent authenticity of the guarantee, and that the advice accurately reflects the terms and conditions of the guarantee as received by the advising party. Now, not meant for this situation, but here we have the advising party is Standard Chartered. They advise Mr. Bedzhamov through Mishcon Ferreira, addressed to him, of guarantee, and in that advice, they say it satisfied itself as the apparent authenticity. The advice accurately reflects the terms and conditions of the guarantee as received by the advising party. Does that mean that here is the guarantee, we are not liable if X and Y happens, and that, in our view, reflects the terms and conditions of the guarantee? Because this is the only advice under Article 10. And if Article 10 means what it says, you have to look at the advice. And the advice says, we're not liable.
Well, I don't understand that, I'm afraid. This is all about something completely different, isn't it? The advising party signifies to the beneficiary that it satisfied itself as to the authenticity of the guarantee.
And that the
It's about
advice,
a question of authenticity.
the advice accurately reflects the terms and conditions of the guarantee. So the advice is the package which they send. It is this document, so-called advisory note, and the guarantee. That's the advice. If it meant the guarantee, it would have said the guarantee.
Okay. Did you make that point to the judge? No. She doesn't mention it.
I'm sorry to
don't get it.
interrupt, but these points, not that I even understand it, but these points, they were not made to the judge. B are not, as far as I'm aware, anywhere in this
They're
appeal.
not in the notice of appeal.
At all.
Anyway, that's Article 10, advisory points, yeah?
Article 12. Guarantor is liable to the beneficiary only in accordance with, first, the terms and conditions of the guarantee, and second, these rules, so far as consistent with these terms and conditions up to the guarantee amount. So that limits the liability of the guarantor.
Well, the judge thought the guarantee, importantly, she said at paragraph 53, Article 12 provides, and then, so she thought that was very important because it actually limits it to the four corners, and then she says the published commentary, 55, on the URDG explains that Article 12 spells out the four-corner rule, namely that parties must look to the guarantee itself rather than beyond it. That is self-evident from the terms of Article 12. Is that appealed?
No, that's what Article 12 says.
So you agree with that actually spells out the four-corner rule?
Yes. But if one then goes to page 449,
so you've got to give me the one again. Which page? 449.
49.
So this is not in the same document, right?
It is in the same document.
Is it?
Well, this is the
No,
guide.
it's the guide.
It's the next tab.
For me, it's the next tab, tab 11, and it begins at 444, the guide, the ICC uniform rules.
Yes, it's a guide. Yes, I'm sorry. I was in the guide already because page 460 is where the commentary on Article 12 and the Four Corners Rule is contained.
Okay, but we're at 449 first.
We're at 449.
Independent.
5.6.
Yeah.
Guarantee not necessarily independent of other relations between guarantor and beneficiary. The principle embodied in Article 5 as regards the independence of the guarantee from other relationships does not apply to a relationship between the guarantee, it should be the guarantor, and the beneficiary that exists outside of the guarantee itself. Thus, Article 5a does not preclude a guarantor from setting off against the claimant of the guarantee a cross-claim for money due to the guarantor from the beneficiary on a separate account if the set-off is permitted by the applicable law. Of course, that's dealing with something rather different. But here we have a letter addressed by Standard Chartered to the beneficiary, clearly intended to be of some effect, otherwise they wouldn't have put it in, which purports to set up a right of Standard Chartered not to pay in certain circumstances, irrespective of their liability under the guarantee. Now, whilst Mrs. Justice Falk concluded that on the evidence before her, and I stress that, on the evidence before her, there was nothing to alter her conclusion that the advisory note didn't qualify the guarantee. It is entirely unclear what, just trying to find the passage I want to look at, Standard Chartered may say, and I just want, if I may, to go to what Lenny Judge said. That's in our supplemental bundle for permission to appeal. Tab 9, page 307.
Sorry, this is in your sub-bundle, page
307. It's an order of the 22nd of June, 2021.
Yeah.
And this is the order by which the judge decided that she would list the application for permission to appeal for a 2-hour hearing, not as a hearing of the appeal. And what she said, page 308, is in my submission absolutely apt. Appears to be common ground the most significant issue, albeit not the only issue, is whether the advisory note modifies the effect of the guarantee. The appellant's position is it does not, at least as a matter of substance. That's Vneshprombank. The difficulty is the advisory note contains an apparent exclusion of liability, which is not on its terms subject to the legal terms or effect of the guarantee, which is not precisely worded. If it's intended to mean no more than a warning the guarantor might be legally prohibited from making a payment due to the effect of sanctions legislation, it might well not be particularly controversial. However, it appears to go further than that, purports to exclude liability, implying that liability could otherwise exist. It's not clear the reference to a potential breach is intended, A, to do no more than bear warning the payment would not be made in fact in circumstances where, if it was made, it would be unlawful because it would actually breach applicable sanctions legislation without affecting the extent of any liability in terms of the guarantee, or B, to exclude liability in any case where the bank forms a view that a payment, if made, would breach that legislation or exclude liability in circumstances where some form of liability would otherwise remain under the guarantee. There appears to be a risk the latter interpretation might apply or might in practice be adopted by Standard Chartered. It's relevant that Standard Chartered is not a part of the proceedings. Any determination in these proceedings about the effect of the advisory note would not bind it. A lack of clarity about the effect of the advisory note would potentially be a reason to conclude what has been provided should not be treated as actually or indeed substantially. That's the relevant test in the terms set out in Schedule 1. And the court will need to be mindful of the factual context which the master made their decision, including the terms of the relevant consent order, the procedural history, the scope afforded to judges taking case management decisions. My Lord, that precisely encapsulates the concerns that we had and have as to where we now stand on the judge's judgment. Because if the money goes out of court, then we won't get it back. I think it's fair to state that in circumstances where VPB and DIA are Russian entities, A1 is surrounded by sanctions issues and is a Russian entity. The Russian court, as we put in our skeleton, are unlikely to seek to enforce a UK judgment when it relates to sanctions.
And that's all good forensic stuff, Mr. Finnick, but it doesn't really have anything to do with what we've got to decide, because you sold that pass when you agreed to the grant of a performance bond, a guarantee, in place of the money. Therefore, the forensic stuff is obviously true, and we know that, but the question is whether they complied with the order. And if they did, no amount of sympathy for your client's predicament at having agreed what he agreed can affect the outcome. I mean, I know it's tempting for advocates to try and play on our heartstrings, but the fact of the matter is this is a commercial matter. You agreed something. The question is, what did you agree and what's happened in consequence?
I accept all of that. And I wish to have no effect on Lordship's heartstrings or any other
You'll probably know, Mr.
organ of sympathy you may have.
You'll probably know therefore hard to find those heartstrings.
One seeks hard enough, but I'm not looking for them. My Lord, that's not quite right because of the nature of the application. And we can we now perhaps go to the judgment?
Yes.
With that in mind.
Yes. So why is it not quite right? Because if we leave heartstrings out of it and put it as sympathy, the fact that we may have sympathy for your client having foregone cash for a guarantee, why is that relevant?
Because he has not got the guarantee that he stipulated.
Well, but that's the question, right?
Yes, it is, but it's not the narrow question. Is the document which was provided with the advisory note on its face similar to, or sufficiently similar to the guarantee which was consented to? That's not the question, because this is a commercial court. It's not a heartstrings court. It's a commercial court which looks at reality. Parties are to be encouraged to agree to the use of unconditional bank guarantees in substitution for cash. We have not got a document which this court can say with confidence will never be regarded by Standard Chartered as an unconditional guarantee in all circumstances, including sanctions. It just isn't. And the judge recognized the exercise that she was involved in was an exercise which is for a variation Now, if we go to the judgment, it's first of all page 9. He sets out the acceptance in principle of a bank guarantee from a reputable a bank.
Which paragraph?
At paragraph 6.
Paragraph 6.
And she then at paragraph 17 refers to the Credit Suisse Standard Chartered Bank correspondence, goes into every guarantee we assume that during the lifetime of guarantee it turns out sanctions are relevant. We're unlikely to be in a position to pay out the guarantee as a claim. That should be the same for all banks. Asked what assurance they could give. Paragraph 19 gave none. The master recognised, paragraph 20, is whether the advisor may substantially change the effect of the guarantee. And well, then we see what, if we go on to page 14, paragraph 23, and these were the arguments that we made. They intended to be read with and form part of the transaction. Sufficiently indicated SCB considers it may have discretion, not bound by any ruling. Provision of the advisory note alongside the guarantee in the terms of the note meant it hadn't been provided in the terms reflected in the order. Because it qualified or purported to qualify SCB's obligation, created a real risk guarantee would not be honoured. The effect was that adequate security was not provided. Then, I think, as I know you would have read this, I want to go on next to page 18 to paragraph 48. And the further point worth clarifying, strictly VPB was not in any respect in breach of the consent order. The order was permissive in its terms. It allowed VPB to provide security by way of a bank guarantee. It didn't require it. That permission fell away in respect of security already ordered by the court if the guarantee in a copy was not provided by the specified date. However, the January order also included a general permission for any further security that the court might order to be provided by way of a guarantee. So that's the future element of it. Strictly, therefore, VPB is seeking the permission of the court, whether by variation of the consent order or otherwise, to permit it to provide a guarantee in respect to security already ordered after time permitted, in terms that include the Credit Suisse wording. Position being it requires no permission in respect to the advisory note. There was no dispute in principle the criteria for relief from sanction should be applied, sanction being, of course, without the court's assistance, the guarantee cannot be used as substitute security. So this was an application for a variation of a consent order. And in those circumstances, the court has and must exercise a discretion. The court cannot simply, no commercial court can, in my submission, correctly simply say, well, I know we've now got Standard Chartered Bank saying they might not pay. We know they're not bound.
Did the judge order that there should be a variation of the consent order, exercising that discretion?
Yeah, if we go on to page 26, she says she remakes the decision to permit VPB.
Sorry, I haven't got these pages you're referring to. Could you use paragraphs?
Of course I can. Yes, I'm so sorry. 90.
90, thank you.
What she did, you can find in her order, which is at page 4 of this bundle. She varied the time, but otherwise held that it complied with the order as varied. Is that not right?
So which page is the order? Which bundle?
It's the second part of the core bundle, tab 5, page 4.
Right, thank you.
Yes, so paragraph 4, she varies it by putting in different times, therefore extending the time.
Well, that's irrelevant to today.
Yes.
So what happened was that she said it complied with paragraph 1 of the January order as varied, and so was entitled to have the money out of court.
Yes.
So the answer is, to my question, that there was no discretion exercised so as to vary the order in respect of the advisory note or the Credit Suisse wording.
Yes, and in exercising that discretion, which was the exact opposite of the discretion which had been exercised by Master Kaye, if we go first of all to page 21, paragraph 64.
In her judgment.
In her judgment, yes.
Yeah.
Terms of guarantee and their objective meaning for hypothetical reasonable person to clear. Highly formal document. These terms do not exclude liability in the way apparently contemplated by the advisory note. I'm very conscious the terms of the advisory note appear to indicate SCB might take a different view. Particularly it states in terms SCB is not liable in the event of a failure or delay in the performance as a result of an actual potential breach of sanctions. As I remarked when ordering an oral permission hearing, it appears to contain an exclusion of liability which is not on its terms, subject to the legal terms or effect of the guarantee, which is not precisely worded. While it could be intended to do no more than convey a warning, the guarantor might be legally prohibited from making payment due to the effect of sanctions legislation, whilst not excluding any legal consequences that follow from that. It appears to go further than that, purport to exclude liability in circumstances where liability would otherwise exist under the guarantee, including where there is a potential breach of sanctions. So the learned judge found, as part of her reasoning, that Standard Chartered Bank had produced a document from which it appeared that they believed that they had discretion and that they could exclude liability in circumstances which catered for that discretion. If any party delays, or any person fails or delays performance of the transaction. And that's an important thing because she had present to her mind when exercising her discretion. Research should have led her not to exercise discretion in favour of the bank, that's what they were going to argue. If we go on, please, to page 23, paragraph 36. I concluded the advisory note does not legally affect the terms of guarantee. Given that conclusion, Credit Suisse wording does not create the additional issues relied on Mr. Fennick, which relied on the combination of the wording and advisory note. My judgment, Credit Suisse wording does not affect the operation of the guarantee. Clear the liability, leaving to one side of the note, is not dependent performed by Credit Suisse, independent of the underlying relationship, and so on. This provides significant comfort to GB that SCB would not be entitled to rely on any aspect of his relationship with Credit Suisse to refuse payment. And then he said Credit Suisse wording is in the nature of a factual recital. And then paragraph 80. However, that is not the end of the matter. My conclusion about the effect of the advisory note does not bind Standard Chartered Bank, which is not a party to these proceedings. The terms of that note appear to indicate they may adopt a different view. GB has some reason to complain that in reality, the guarantee that was provided was not what he anticipated and what he had given VPB a final chance to provide. GB thought he was getting what was scheduled to the February order, no more and no less. The guarantor appears to be saying that it might not perform under the guarantee in certain circumstances. and indeed in precisely the circumstances that GB is concerned about, originally led to the inclusion of the Sinsley paragraph 12. This, together with Standard Chartered Bank's unwillingness to withdraw the advisory note or give any assurance, has in fact led to uncertainty. Further, he has a fair point to advise that emphasise the importance of knowing what was in the precluded version of the guarantee. If VP was able as it was to procure further communication from SCB about the guarantee following its provision, it is likely it would have been unable to do more to avoid the surprises that accompanied the final version, as well as ensuring that it only agreed a deadline it was properly satisfied with met. Master was justified in taking account of the timing breaches as part of all the circumstances, and in referring more generally to the long history, she correctly considered matters in the round. So the judge accepted considering matters in the round, but ultimately I don't consider that sufficient to preclude VPB from substituting the guarantee as security. My conclusions about the effect of it is that GB has in fact been provided with a guarantee contemplated by the consent order, objectively interpreted. The fact that SCB provides an additional document which does not legally affect the terms of the guarantee cannot mean the guarantee does not comply with the terms of the consent order. Now, Lord, going back to the point just made by the learned judge, we asked repeatedly the sight of the guarantee as executed. If we had been provided with the guarantee together with the advisory note, which is what we got, then in my submission, it's tolerably clear that we would not have consented to it. And the judge correctly found, as she recites at paragraph 80, in reality, Mr. Bedzhamov has some reason to complain. In reality, the guarantee that was provided was not what he had anticipated and given him a final chance to make. So what we received was not what we had stipulated for, which was a guarantee shorn of any qualification, actual or purported, but was one in which Standard Chartered Bank, apparently as a standard practice, had sought to carve out for themselves a discretion not to pay. And it's a kind of discretion not to pay which one can readily envisage. Forget the details of Mr. Friedman and Mr. Avon and Mr. German Khan. The counter guarantee, which is in the bundle and requires Credit Suisse to make payment within 3 days of a demand. So we make the demand on Standard Chartered, they make the demand. There's no such time limit in our guarantee. So they have their 3 days, they're not paid. They're not paid because the money is sitting in an account, presumably of A1, or it might be A1 Capital, who knows, which at that stage is frozen. So Credit Suisse says, we can't pay, the money we were going to pay with is frozen, and as a result of sanctions, we cannot provide any significant financial benefit. If we just go to the authorities bundle, tab 6, page 331, I'm just taking the key point here. This is the UK Financial Sanctions General Guidance, begins at 320, and at 331, making available funds or economic resources for the benefit of a designated person. If funds or economic resources are made available for the benefit of a designated person, they obtain or are able to obtain a significant financial benefit. This may constitute a criminal offence. In this case, financial benefit includes the discharge in whole or in part of a financial obligation for which the designated person is wholly or partly responsible. So, A1, Mr. Friedman, whoever it is, doesn't matter, is sanctioned. The payment of monies by Credit Suisse for the benefit of those individuals to discharge the financial obligation which has been incurred would be a breach of sanctions. And it's Swiss sanctions, EU sanctions, broadly the same, with minor differences. So, in those circumstances, it would be a fact that that Standard Chartered would say, because of failure to perform by a party to the transaction, Credit Suisse and or A1, due to actual or suspected sanctions, we are not liable. That ignores the key question, which is the only proper question qualifying this guarantee, is whether Standard Chartered would be in breach of sanctions in honouring a guarantee which it had made independently of the counter guarantee, therefore independently of any sanctioned person, to Mr. Bedzhamov. Now,
So
if Mr.
Oh, sorry.
May I just finish the sentence, then of course I'll ask. If Mr. Bedzhamov had been, as we originally feared, the sanctioned person, then Standard Chartered would say, no, sanctions can't pay to Mr. Bedzhamov, hence pay it into court and let the court decide what to do with it. And it will become part of a blocked fund. But in this case, Standard Chartered obligation would, absent effective reliance on the advisory note, require them to pay Mr. Bedzhamov even if Credit Suisse failed to pay under the counter guarantee within 3 days, citing the sanctions. Now, in those circumstances, it is not illusory and not fanciful to suggest that Standard Chartered, having put those words in for a reason, would not come to this court and say, please do not make us pay. We have made clear from the outset the circumstances in which we won't be paying. Those circumstances have happened. Whether they're right or not, Credit Suisse have blocked the account, won't make the payment. And therefore, we have stipulated to Mr. Bedzhamov we won't pay. Now, whether they win or lose is a different matter. But this judgment of Mrs. Justice Falk does not go anywhere near preventing that from happening. And if we go back to the judgment at page 26, paragraph 89.
How can it?
She says, whilst Standard Chartered is not bound by my decision, I trust it will accord appropriate respect to what I consider to be a clear conclusion about the legal effect of the guarantee. If the point arose in practice, Standard Chartered Bank did seek to take a different view, that would have to be resolved in a normal way. I don't consider the existence of that possibility should lead me to determine the appeal in GB's favour. In other words, there would, in these circumstances, be delay and cost. It would not be as effective as an on-demand guarantee. It would not be subject to the jurisdiction of the court immediately as money in court. It is not, therefore, the guarantee which is stipulated for. My lady, I know you're going to ask me a question, and I'm sorry that I ran on.
No, that's fine, Mr. Fenwick. It's just therefore what you had just been focusing on was the another person element, which brings in what you say are the complications in relation to Credit Suisse and broadens the uncertainty. That was what you were focusing on. And I think that all that you've just been submitting, so that I understand that I've got that right, is back to my previous summary, which is whether it's part of the guarantee or not part of the guarantee, it's part of the package and it creates sufficient uncertainty, possibility of cost and delay, that we haven't got what we bargained for.
Yes.
End of story.
And where there is a discretion, which it clearly is, and it's not what we signed up to, one can't simply say, yes, it is what you signed up to, because the guarantee bit is the same. And that really is the four corners of our appeal, which we set out in our grounds.
But I should say at this stage that I don't understand the references to discretion that you took us to in the judgment to be an exercise of discretion in relation to variation. They are references to the master considering relief from sanctions, and in that context there's a reference to discretion, and otherwise, as I understand it, Mrs. Justice Falk is saying, for example, at paragraph 82, yes, I've taken into consideration those matters, and you read those paragraphs to us, Mr. Fenwick, but actually my conclusion about the advisory note and I've read it Swiss wording, means that it's within the consent order, full stop, no variation. I just thought it out to flag that up again because I'm confused about that.
Yes, well, there are 2 points there, and he's right to distinguish them. My first point is, as your ladyship said more clearly than I seem to have managed so far this morning, that the package is not what we signed up to and not what we agreed. We agreed for a guarantee simpliciter with nothing else, and that's not what we got. The consent order has not been complied with. Secondly, in my submission, where you have an application for the variation of a consent order which was intended to be final and give a cut-off date, and intended to reflect only specific wording on its own, the document we got, but we weren't to get, then when something different is provided, including the words at the request of Credit Suisse and with an advisory note, that brings in the court's discretion as to whether in substance it should permit the variation, whether it's extension of time. You can't simply say, well, it's only 20 minutes, so I don't need to worry about anything else. If you find that although the guarantee looks as though it's unqualified, although I think the advisory note doesn't matter, despite the fact that I think Standard Chartered might come back and fight, then you got what you bargained for, because that would, in my submission, run a coach and horses through the whole point of saying, yes, you can have a bank guarantee, and it doesn't really matter if the bank guarantee doesn't come in the form you expect because it's got some kind of qualification, good or bad. We stipulated for a single piece of paper, and we got a package. The effect of the package is to create doubt. That package is a variation. One can't simply just look at one bit of it. That's a number.
Can I just ask you this, Mr. Benny? I'm beginning to get to the nub of this. You don't say that expressly that the judge was wrong to say that the advisory note was not a term of the guarantee. You say she may or may not be right, it's not binding on SMB. You do say that the order was not complied with because you didn't get substantially what you had bargained for under the order.
And agreed to, yes.
And agreed to. Which must mean that you agree with what I put to you right at the beginning, which is that the real question is whether what happened was in compliance with the order as amended. And what I'm trying to do now is to put flesh on the bones of your submission, which was a combination really of your first and second points that you've just put to me and I've noted down. If we go back to the order in the core bundle, part 2, and first of all, the first order says, it's ordered, and this is by consent, that the claimant shall be permitted to provide security for the following amounts, ordered or agreed to be provided by way of security for the costs of the first, it's page 131 in core bundle 2. So the claimant shall be permitted to provide security by way of security for costs by way of bank guarantee substantially in the terms set out in Schedule A. And the second part of the order is in paragraph 5 as replaced, isn't it, by the second order. And in paragraph 5, it's provided that in the event of such guarantee and the copy of the register has not been provided by a certain time, the permission shall cease to have effect. So the question is, did they provide such guarantee, which you accepted earlier when I put it to you, did they provide such guarantee full stop. And you say, well, in order properly to understand this order, they did not provide the guarantee because they provided a guarantee subject to conditions. They did not provide the guarantee substantially in the terms set out in the schedule because it was subject to uncertainty, and that was sufficient to make it a non-compliance, and therefore they did not have permission to provide something that rendered that uncertainty. And that's what, and that is exemplified by your evidence, if there was evidence, that you wouldn't have consented to it, and anyway, your conduct in making a big fuss once it had been done. And that, in a nutshell, I think is what you say.
Well, yes, and with one sentence added, if I may.
Sorry, you're very quiet again.
Well, so with one sentence added, if I may,
Mm-hmm.
and I'm glad we're back in court and I can stop mumbling.
You see, you've got an aeroplane now, which is sometimes, in this court, aeroplanes go round and round for hours for some reason.
Added to this, that in identifying what arguments may be raised as to the effectiveness of the advisory note, I am looking into such matters that I know and have in mind. The court must recognise that Standard Chartered will have given careful consideration to what to put into this note and what it meant, and may have other reasons to support its effect in qualifying the guarantee, which I have not been able to identify, and the court should not conclude that they are a bunch of people whose best attempt at avoiding liability is the rather graphic comment that my Lord the Master of the Rolls made as a possible caveat. We won't pay, so bad luck. This was presumably a carefully thought out, intended to have some consequences, and the court doesn't know it. We can't assume that Standard Chartered Bank won't be in the court below, in front of this court, seeking to go to the Supreme Court to argue why it says it shouldn't have to pay. And that, Lords, is my submissions, unless I can otherwise assist you.
Well, before you go, Mr. Fenwick, it's good to finish on a high note, but what I'm having trouble with at the moment is seeing how the requirement that you get something that, if I can put it this way, gives you comfort, and don't get any caveats or argument, is part of the order. You'd had a massive amount of argument in getting to this stage of the second order, second order, which gave them 2 days, and basically you were saying, do it or forget it, which was perfectly reasonable, bearing in mind all the messing around that had taken place. But knowing all that messing around, surely you could have put in bank guarantees substantially in the terms set out in the schedule. I don't know. I mean, do we have to read into the order without caveats?
Lord, yes, may I just want to go back to the first order, which is at, I think, page 14, tab 14, page 131 of Core Bundle 2.
Yeah.
And this was the first order, and it did say substantially in terms set out in Schedule A to the order. And it then had, because of the sensitivity of what was contained, but the history was that we kept asking for an execution version and they wouldn't give us one, said they couldn't give us one.
Yes.
Paragraph 2, on the provision of the executed guarantee on such said terms, evidenced by provision of copy of the register, the first defendant solicitor shall within 3 working days confirm claimant solicitors either they're satisfied the guarantee is in accordance with the terms of this order, or his reasons for asserting that it does not comply. And then we then have within 3 days serve an application for a declaration that doesn't apply, and then apply evidence and a determination. So it was already in prospect that the precise documentation provided was highly relevant and needed to be scrutinized. And the version, which was substantially the same, was solely the page which we see at 135.
So you never confirmed.
I'm sorry?
You never confirmed, your solicitors never confirmed that they were satisfied. They did give reasons for asserting it did not comply, is that right? Under paragraph 2.
Yes, well, of course, it happened the other way. Because they didn't supply it in time, that wasn't triggered. They applied for relief from sanctions and variation, and we immediately responded to say it doesn't comply.
But I thought there was, okay, but there was correspondence,
Yes.
but not precisely in the terms of this order.
Yes, including our request that they should withdraw the advisory note. If it means nothing, withdraw it. And they refused to withdraw it. So if it means nothing, then why not withdraw it?
So you'd actually already made provision in the order for it to be not complied with, or there to be an argument about whether the form complied with it. And you say to you that's really significant because everybody knew that if they added in a little caveat,
Yes.
You were going to take issue. Why didn't it get put like that to the judge?
Well,
Or the master? Because they were too close to it? Because they're both assigned, aren't they, to the case?
yes. I mean, they understood that because they knew of that procedure. What we said all the time was this does not conform to...
Where's the correspondence? Could you just show us the actual correspondence? I never thought I'd be heard to say, please show me the solicitor's correspondence.
I'm surprised and delighted.
Where is it?
Let me just make sure I can get to the right place.
I mean, I'd like you to start, Mr. Fennick, before, so between the two orders.
Yes. But we need to be in the supplemental bundle. I'm just getting the dates.
So would it be AKB 10?
It's an MDS 24.
MDS 24, that's tab 6.
And I'm just going to pick it up, if I may, at page 170, which I appreciate is
170.
before the consent order was made, but it gives the background. 13th of January 2021, Mishkon's right to Keystone Law, referring to the application. We've yet to receive a reply to our letter, which again requested your client provide a copy of the proposed guarantee.
So is this after the first order?
No, it's before.
Before?
Before, but one needs it to see how we got there.
Yes, no.
Provide a copy of the proposed guarantee on standard charge paper, an execution form, with the name of the intended signatories printed on it, attaching the draft guarantee, and confirming what else would be in the execution version and who would sign it. For the reasons referred to in our letter, this should be readily obtainable. We again invite you to provide such a document. Our letter also sets out outstanding issues reflecting the wording of your proposed guarantee and enclosed a revised draft order. Please reconsider. Then 171, 18th of January, we still haven't received a substantive reply. 173, response from Keystone. Appear to be two outstanding issues. You insist on seeing a copy of the proposed bank guarantee in execution form, attaching the draft guarantee and confirming what else would be in the execution version that would sign it. And two, you insist on further revised wording in relation to paying money into court. We address these in turn. Contrary to the assertion in your letter of 13th January, it's not readily obtainable to obtain a draft execution form, proposed bank guarantee. It should not be surprising if they don't readily distribute unexecuted versions. Similarly, a letter is not available. The normal practice for the terms of bank guarantee to be agreed with the issuing bank, and then for the bank to execute guarantee. You don't explain why your client needs to see it rather than a draft. Of course, if the executed version does not reflect the draft, or is not properly executed for some reason, our client will not apply the terms of the order. Security will not be replaced. I think we can leave that one. Then the order, 22nd of January, page 176. We note the form of order has been revised. Doesn't include the wording payment into court. The audience does not propose a mechanism either for our client to consider and object to the document of which it will not previously have had sight, nor provide the Court Funds Office with any certainty in the form of an agreed order or direction. Our position is we should have the opportunity to inspect a copy of the original executed guarantee together with evidence prior to the sums being removed, and then two, over the page, our client should then either confirm the documentation satisfactory or provide detailed reasons, written reasons why he contends the guarantee and confirmation not satisfactory. Should be a mechanism either in the form of a court order or in the form of permitting release if our client has not issued and served an application, confirmation of non-compliance and further directions.
So then there was an order, right?
Then there was the order of which we just looked at, of the 26th of January 2021.
Right. And then the first letter afterwards is Keystone on the 12th.
Yes. And then we get, court arranging for the formal issue, standard charges who had previously indicated they were happy with the wording of the draft guarantee, have now reverted with proposed amendments to the final version. Here's a red line. We don't consider these changes place your client in any worse position or affect the operation of the guarantee in any way. And then there were a number of changes, including over the page deletion of the 12th paragraph. And the 12th paragraph was the one which said they were not aware of any factors which might prevent them from paying. They refer to our correspondence. Then over the page, our client sought to include the wording in the 12th paragraph. Credit Suisse raised the wording standard charge who confirmed they were comfortable. Our client understood the wording to be agreed. This suggests from standard charge to the contrary. And then we wrote to you on 23rd September proposing new workers. We also
I'm beginning to see why I'm so hostile to reading solicitors'
I know, but once you get into it, you get into it. I'm sorry. I'll move as quickly as I can.
It's not your fault. It's just they rehearse all the history of the world, part 1.
Well,
keep going.
Hopefully we won't need to get to part 2.
The guarantee is also already stated to be irrevocable.
Yes.
Then we remain of the view that the comfort you sought was unnecessary. What's that?
I'm sorry, Your Lordship is reading.
I'm at point 3 on page
Point 3.
181.
That's the wording. That is the order that money should be paid into court.
Yeah, okay, so next steps.
Then we have to go, oh, I love the way account bundles work. done, AKB 10. We now go back, please, to page 20. I think that may be. Yes, 24 in tab 4. So we refer to your third letter. We know you've been unable to provide an executed guarantee in the form set out and stipulated the order. Now request our client agrees a revised formal guarantee by 4 p.m. today, without any proper explanation for the change in agreement you seek, and where you fail to provide the red line from standard charter.
Having made all that, they say, notwithstanding, our client is prepared to agree to your client's revised form of guarantee if it's provided, together with a copy of the register. Enter into a consent order. We've attached the revised version. So you drafted it.
Yes, that didn't. Then we go to page, carrying on here, page 26, 15th February. That won't do. Can we please have amended consent order for the 19th? Then we have a response on the 16th of February, the second page, as a final compromise. Our client is prepared to agree a variation of paragraph 5 so that it provides your client with 12 million on Friday the 19th of February to provide the revised form of guarantee, failing which the form of security shall remain as previously ordered, provided the liberty to apply provision is also removed from the order, so as to make clear the parties intend this to be the final order in relation to the form of security to be provided by your client in these proceedings.
Right. And then the master queries whether you really intended to delete the liberty to apply, and you did, and off you go. But what this correspondence doesn't really take it much further than the submission you've made, which is that we made a lot of fuss about the form of the order and knowing what it was.
Yes.
And eventually we agreed the order and said it's got to be in this form, varied by the deletion of clause 12, and you've got to have it in 2 days. And you say they provided uncertainty. Is there any law that, is there any case that helps you on that? Is there any case in any field? The one you refer to in your skeleton is about, I can't remember what it's about insurance, isn't it?
About?
Is it about insurance? I can't remember. You refer to a case...
Premier Motor Auctions.
Yes, Premier Motor Auctions.
That was a case, we just look at it quickly, in which Mr. Justice Snowden held that an after the event policy was good enough following, I think, the decision Mr. Justice Stuart Smith, as he then was, in a case. It's tab 3, page 19 of the bundle.
It's really a very different case.
I'm sorry?
It's really a very different case.
It's a very different case, but if one goes to what Lord Justice Longmore said at page 29, paragraph 27, or 26, if Mr. Elliott, who was a claimant, managing director, is not believed, the companies would be liable for the cost of PwC and the bank. The judge said it was something of a leap to conclude that disbelief of Mr. Elliott would provide grounds for insurers to avoid the policies. Again, I cannot with respect agree. Of course, it does not follow that insurers would avoid. Difficulty is neither the defendant nor the court has any information with which to judge the likelihood of such avoidance. One knows that AT insurers do seek to avoid their policies if they consider it right to do so. See Persimmon Holmes against Great Lake. The landscape after trial may be very different from the landscape as it appears to be at present. It's unsatisfactory to have to speculate. The judge felt he could rely on the fact that proposals for insurers are made by joint liquidators, investigate the claims. All this is true. Best professional advice cannot cater for cases of non-disclosure. Neither the defendant nor the court have been provided with the placing information put before the insurers. Even if it had been provided, it's unlikely the court would be satisfied the prospect of avoidance is illusory. Even at the jurisdictional stage of clearing security costs, defendants must be entitled to some assurance that the insurance was not liable to be avoided for misrepresentation or non-disclosure. I cannot see on the facts of this case defendants have that assurance. Now, substituting for that, exactly parallel, we do not know whether Standard Chartered Bank would seek to rely on it, but they must have put it in for a reason. We know that banks don't want to pay on guarantees if they haven't been paid or think they're at risk of not being paid. Is the court in a position to speculate, as with respect the lending judge did, that Standard Chartered would probably listen to her words of wisdom and pay up without us needing to go to court? Or is it reasonably possible, I don't have to go higher than that, that Standard Chartered would say, no, you're going to have to sue us and we'll raise the arguments. Uncertainty, different, not what we bargained for. That's the closest authority that I can find.
Okay. Anything else? Anything else? Thank you very much, Mr. Kaye. Mr. Georgy.
Please, the court.
Now, while we're getting pronunciation right,
It is
you are
Georgy,
Mr.
yes.
Georgy.
Absolutely spot on.
Mrs. Justice Falk is Mrs. Justice Falk, not Mrs. Justice Falk. Just to be clear.
The appeal is really, in my submission, relatively straightforward. The judge below was, of course, concerned with an appeal from the order of Master Kaye. Master Kaye was concerned with whether or not there was compliance with the order for provision of security, and if not, whether the order should be varied. And she determined that there was not compliance because the advisory note was an integral part of the guarantee, and therefore the guarantee that was being provided was substantially at variance with that required under the consent order, and one representing a substantial dilution of the protection given to Mr. Bedzhamov. As a consequence, she refused to vary the order, and the application by the claimant was dismissed. So when we get to the appeal in front of Mrs. Justice Falk, we are concerned primarily with whether the master was right to find that the advisory note was part of the terms of the guarantee. And the judge needed to make a decision on that point.
And she decided that it was not, and Mr. Fenwick has helpfully made clear that is not appeal.
Exactly.
Right.
Though he complains that she shouldn't have made that decision because Standard Chartered Bank were not there. That's ground one of their grounds of appeal. But that...
Well, I don't think he does say she shouldn't have made it. I think what he says is it's not binding on Standard Chartered. And not being binding on Standard Chartered is relevant to what we now know is the burden of his submission, which is that this has created uncertainty which is not within the four corners, not of the guarantee, but of the order.
Yes. So I think we can probably cut to the chase, because
So
that's the point, as I think was put by Lady Justice Asplin some time ago to Mr. Fenwick.
Correct.
And that's where we get to. So just taking it in stages, the document that was provided in the form of the executed guarantee contains all the terms of the guarantee. On the basis of the unchallenged finding of Mrs. Justice Falk, there are no other terms. The advisory note is of no legal effect. That is her finding, which is not challenged.
Where does she say that? No legal effect.
So if I can pick up the judgment, tab 6. you were taken at pay at paragraph. You were taken to paragraph 65 by Mr. Fenwick. Don't think you were taken to paragraph 66. Terms of the guarantee are clear, and for the reasons I've already given, I do not consider that the advisory note has any legal effect to the extent of SCB's liability under the guarantee.
Sorry, 60.
66.
Oh, I'm sorry. But does she consider, because the bit that Mr. Fenwick read us at paragraphs 80 onwards, where she says, I think Mr. Bedzhamov, and I hope I've got that pronunciation right, when she says Mr. Bedzhamov is entitled to be upset, does she actually consider whether that entitlement to upset is a breach of the order or an implied term of the order?
Well, she does in my submission when you get to paragraph 82. So after the paragraphs that where she recites Mr. Bedzhamov's concerns and her views on that, she says ultimately, I do not consider that these points are sufficient to preclude VPB from substituting the guarantee as security. My conclusions about the effect of the advisory note and the Credit Suisse wording, just pausing there, she found that the Credit Suisse wording was immaterial and didn't prevent the guarantee being in the terms of the schedule to the order, mean that GB has in fact been provided with the guarantee contemplated by the consent order objectively interpreted.
But that is not appealed, actually, except insofar as the Credit Suisse wording is said to be relevant. But what is said now, you may take a point about it not being in the grounds of appeal, but we'll come to that. What is said is that under the terms of the order, which said you had to provide a guarantee substantially in the form, and you have to have delivered the guarantee, provided the guarantee by a certain date, you don't comply with that order by sending a document which says in terms you might not comply with it if there's an argument over sanctions.
I understand that argument, which I think as it's been vocalised is today for the first time.
Well, I think it's what he said to Master Kaye, to be honest.
In any event, let me deal with it. I don't want to sort of take points about matters being raised late, because I can deal with it. I can deal with it now. I'm perfectly capable of dealing with it now. And one comes back to the terms of the minute of order. I mean, the order of January, and then, of course, the variation of February, which the judge considered to be clear and had no difficulty in understanding and concluding that the guarantee had been provided in accordance with the terms of the order. And if we go back to the first of those orders, at tab 14 of the core bundle part 2, what the focus is on is the provision of a guarantee. So the guarantee under paragraph 1 of the order shall be about guarantees substantially in the terms set out in Schedule A to this order. So what that requires the court to examine is, first of all, to determine what are the terms of the guarantee, and then secondly, to determine whether those terms are in the same terms as the schedule, or if not, substantially in the same terms as the schedule.
Well, the answer to that, on the unchallenged findings of the judge, is obviously yes.
Yes. And the order is clear. There's no ambiguity in this order. It's very clear, and of course, rather important that it should be clear, so that there would be clarity as to what was required.
What Mr. Fenwick effectively says is, you can see from paragraphs 2 3 and 4, that the parties were extremely concerned about the form of what was provided, and the order contemplated an unconditional guarantee, even though those words are not used. Bank guarantee equals unconditional guarantee. And this is not an unconditional guarantee. This is a guarantee into which has been injected uncertainty and litigation.
Well, it is an
Not what was
unconditional.
intended.
It is an unconditional guarantee. On the judge's finding, the advisory note forms no part of the terms of the guarantee. You look at the terms of the guarantee, which says that they unconditionally agree to perform the irrevocably perform the obligations contained in the guarantee, and you have got an unconditional guarantee. It's in leaving aside the immaterial Credit Suisse wording, the guarantee, and I emphasise that that's what we're concerned with. The guarantee is in exactly the same terms as the schedule, as amended by the February order. Now, one can see that because the order of January provides for compliance if it is in substantially the same terms as the terms in the schedule, that there might be disagreement between the parties where there is not an exact match in terms of the terms of the guarantee and the terms of the schedule. And so in those circumstances, you would need to have a determination by the court as to whether it is substantially in the terms. But that doesn't arise in our case because the judge has found that the guarantee is in the terms of the schedule to the order as amended. And it really is as simple as that. The judge has applied the clear terms of the order to her findings as to what are the terms of the guarantee. The box gets ticked because there is a match, and that is the end of the matter. And that's an exercise as to which she had to make findings if she was going to deal with the appeal. She couldn't have dealt with appeal on the basis, well, it's arguable whether the advisory note is included or not. She had to reach a decision because she had to determine what are the terms of the guarantee that has been provided.
Is there any law on the implication of terms into a consent order? I have in mind that wonderful book written by Sir David Foskett.
Yes. I don't know off the top of my head. I did print out an extract before I came over, actually, because I wondered if there might be some questions about consent orders generally, as to which he does cite the position that you apply the same approach as you do towards construction of, in terms of consent orders, toward construction of contracts. I left the rest. I'm afraid I left it on my desk, so I don't know whether it says anything about implied terms. But
would it not be an implied term under the rule of necessity? Would it not be an implied term that the I'm trying to formulate it. Probably the reason it hasn't ever been formulated is because it's so difficult. But it would be an implied term that the unconditional nature of the guarantee would not be vitiated by statements creating the risk of litigation. Why not?
There's authority about the danger of seeking to imply terms with the benefit of hindsight, and that would seem to me to be a classic example of falling foul of that rule. I don't see that there's any necessity for such a provision in order to make the consent order work if there is even a principle for implication of terms into consent orders, I could see reasons why that
The point
might
is,
not automatically be the case because of
the
the need
point
for
is-
certainty as to whether an order has been complied with or not. I think the short answer to it is that such a term is not necessary to make the order work. What the order is concerned with is the terms of the guarantee, and if you have got a document which has no contractual effect, then as the judge has found, and as is not appealed, then that does not vitiate the unconditionality of the terms of the guarantee.
but she accepted that SCB may argue that it does.
Yes, but she's got to decide. She has got to decide on. She has got to decide on the appeal that was before her, whether or not the guarantee contains the advisory note or is qualified by the advisory note or not.
So you say it's tough, and it's tough because if they wanted such a term, they had to put it in.
Yeah, I mean, if they wanted to deal with any uncertainties, even not legal uncertainties, but possible arguments, they would have had to make some provision for it. I mean, the deal they've done is the deal that's set out in the consent order. I mean, I come back down to this. The consent order is clear in its terms. It's absolutely clear. And the judge went through a very straightforward process, considering what were the terms of the guarantee and then whether it matched. And it did. I mean, I can't really put it I can't really amplify it any more than that. It's a very simple and straightforward point.
And the more you say, the more trouble you may get into, Mr. Georgy.
Well, I'm not sure I will, actually, with respect. I think if one's starting to resort to implied terms, you're really in
Well, I tell you
troublesome
what-
territory
tell you
in
what,
circumstances where, of course, no such argument was advanced.
So giving the one day estimate the benefit of the doubt, Mr. Georgy, I'm going to suggest that we rise now, since you obviously don't have very much more to say, and have a look at that great little book written by Sir David Foskett, and see whether you can add anything to what you've already said, which is the order's the order's the order, and you don't imply terms very often, if at all. And what Mr. Fenwick is trying to do is to imply a term, just to satisfy me that you're absolutely right about that, not only apparently, but also with the benefit of authority.
I'm, of course, very content to do that, but
We'll come
just
back
to make the
at 2
point that,
o'clock, and we'll expect to be finished shortly thereafter.
yes, but just to make the point again that I'm not, that no implied term argument has so stated, has been advanced until a few moments ago as a possibility.
Well, except that's what it really was all along. That's what it
I think that's,
really was.
with
I
respect,
think
is
it's
huge. I certainly didn't make that leap from reading my friend's skeleton or his grounds of appeal,
No.
and of course no such argument was put before the judge.
Well, if you're right, you'll be able to knock it on the head very, very quickly.
Thank you, my lord.
So is that a reasonable? Are you happy with that? Okay, we'll return to that.
Sorry? No. I just need to get on the internet. Thank you. Oh, have you? Have you got? I think I just realised when I printed it out, I must have done. Yeah, it might be easier. Don't mind. Oh, I've got to put the whole code. Oh, okay. Yeah, it's probably easier for me to do that than actually. Shall I? Did you say back at 2?
Yes.
Maybe we should just go back to chambers, actually. Very slow.
I've got the internet.